The views, thoughts, and opinions expressed on the Nova Society are those of our guests and panel members and do not represent the views, thoughts, and opinions of any institution any member of the Nova Society is associated with. The material information presented on the Nova Society is for general information purposes only. Reproduction or dissemination for the purpose other than education is prohibited without express written consent of the Nova Society. We'd like to welcome everyone back to the Nova Society, and today we'll be having a very short conversation with our panel regarding a couple of decisions that came out of courts in the recent days. The first out of D.C. Circuit Court of Appeals, and the second out of Michigan. And that case speaks to parents that have children that engage in mass shootings. We'll also be talking about the recent developments in Nevada as they relate to the primary for the Republicans and what could be potentially a very embarrassing result for the former governor of South Carolina, Nikki Haley. So let's listen in. Appeals three-judge panel ruled on the immunity claims of the former president, that basically the president of the United States is immune to all prosecution for everything they do. So, of course, one of the judges, Judge Pan, who would just ask a brilliant question during the hearing, was that, so what you're claiming is that the president of the United States can send out SEAL Team 6 to murder his political opponent, and he cannot be prosecuted for that. He is immune. And the lawyer basically came in and said, well, he can be if he's already been impeached and convicted by the Senate.
Which would solve a lot of our problems.
So yeah, that was the argument, Priscilla.
Right? If you can solve any problem that we have just by sending the SEAL Team 6 to Mar-a-Lago, whacking the former president, and then having Chuck Schumer kind of say, "Nah, we're not removing the president. When he's not going to be impeached for this," and that was actually the argument that they tried to make.
Yeah, because he has full immunity because Trump got what he wanted, which would be full immunity from for all presidential acts, because he forgot in all his arguing that would apply to everybody, not just himself.
Right. So a very interesting ruling came out of the 10th Circuit. The pundits are basically saying that they do not think the entire 10th Circuit will take up the case because this is so cut and dry. Matter of fact, everything that I've heard about this decision that was handed down, and it took longer than people thought it was going to take. People thought it was going to only take a couple of days because it seems so cut and dried. But after they read the opinion of the three-judge panel, which was unanimous, kind of rare that it's unanimous, not just somebody signing on to the opinion, but actually a unanimous decision of a bipartisan court as far as ideology is concerned. They really didn't, when they read this opinion, they said, now we know why it took a month to craft this out the way they did. That was this well written and ironclad. Even the Supreme Court probably won't even want to hear this case because the Court of Appeals decision is so good.
What's the decision?
The decision is that there is no presidential immunity. The president can't simply strip citizens of their rights. The president cannot be out of the reach of Congress and the other branches of government. So the president cannot commit any crime he wants or she wants in office and then be immune from prosecution. So one of Trump's arguments was that the president has to have full immunity for any act whatsoever, including murdering political opponents, because if not, then when the president gets out of office, the other party is going to impeach and going to indict and going to prosecute and persecute and all this and that for all these actions that the president did while in office, even though this has never been a problem before. The way they're doing to him now, the Democrats, of course, because he didn't do anything wrong and everything he did was right and perfect. And therefore he needs to be given this immunity. But of course, he's forgetting that that would apply to every single president. And of course, and the example used by the judge in the appeals court was to Trump's lawyer. So you're saying that the president could order the SEAL Team 6 to go and murder a political opponent, and that would be fine. And of course, the Trump's lawyer prevaricated and began with this long-winded statement. And the answer is obviously yes. But he said, well, blah, blah, blah. And I also noticed that among Trump's lawyers, whose name I can't remember, many winded statements, was selling documents, and I don't know if he said I think he said classified documents to other nations, which he did not think was a crime. So he inserted that wording in there. And of course, Trump has done that. At least I assume he must have done that, maybe, allegedly, because the lawyer stuck that wording in there and said, and I don't think that's a crime, or I don't think that's illegal, or something like that. And I thought, what is this man saying? So yeah, and so now another thing that the appellate court did that I thought was very smart was they gave Trump and his team until November 12th, until this coming Monday, either to appeal to the Supreme Court, or to I forget what the legal term is, to appeal to the 11 judges, the way he had done before, in some other case that he was appealing, and the 11 judges just simply wouldn't even bother to hear it. And they just said, forget it. And so because Trump wants to delay and delay and delay and delay, so he has until Monday to bring it to the Supreme Court. And the Supreme Court may, of course, refuse to hear it, in which case it goes immediately to Judge Tanya Chutkin. And although the March 4th trial is now off the docket, if Trump brings it to the Supreme Court and they decline to hear it, it goes back to Tanya Chutkin. And if Trump brings it to this 11 court appeal court, whatever that is, and they decline to hear it, it immediately goes back to Tanya Chutkin again, and will go back on to the trial docket at whatever date. So that's another reason I think that the 3-judge appeal court took 28 days and 57 pages to effectively back Trump as much as they can into a corner, and basically be very clear and very strong in their wording, not provide any wiggle room, and provide a very rigid deadline, so that he cannot use a delay tactic to his advantage, to the best of their ability, at least.
Right.
Have I answered your question?
Cool.
Yeah.
Probably too much.
So it's actually called en blanc.
Thank you. I knew there was a term. I forgot it.
Well, en banc.
Yes.
And when an entire appellate court hears, when all the 11, most appellate courts there are 9 or 11, and
11. Right.
But in some, not depending on the jurisdiction.
Well, this one is 11.
Right.
Yes, and that's the term. Correct.
Right. So the idea is that he could request the entire court hear this, although it's very rare that the entire court gets together to do it. It does require only 4 judges to say yes, but of course now he's got 3 already out of the 11 that say no. So he's got 4 of the other 8 that have to say, yeah, we want to hear this, but generally, historically, the appellate court does not, especially when a ruling is this unanimous. They won't do it. And with the Supreme Court having to hear tomorrow the case about Colorado and the Colorado removing of him from the ballot, it seems unlikely that the Supreme Court would really want to get involved. What do you think, Scott?
Well, I don't like to predict, as you know.
Fake news. You love to predict. You and I love to predict.
But I will say that, one of the reasons I think that it took so long and was beginning to seem like it was part and parcel of the stall tactics that Trump uses is that they were circulating it to the other judges so that they could get sign off on it, and it would not, and so we can skip the next step. And it seems unlikely from what I'm reading and seeing on television that the Supreme Court would take this up. And then as Brooke said, it goes back to Tanya Chutkan's court and could get started. I suppose it could get started as early as May, and but more likely, I think sometime during the summer. So, yesterday was an interesting and good day on a number of different fronts. The one that really stands out in my mind is not really this one or even what happened in the House yesterday. But the Michigan verdict on that a mother and the father will be up for trial soon can be held responsible for their child being a school shooter, and that the school shooter's mother is going to prison too, and I imagine the father will probably be following. That was the story of all the good stories that we saw yesterday and interesting stories that we saw yesterday that I think is going to have the longest impact.
Yeah.
And I'll tell you why I don't think that this one is going to have that long an impact. First of all, it was, I think, a slam dunk. It's a ridiculous thing to even ask. And it was completely brought up by Trump for the purpose of delaying the trial. There was no way that he could have expected that he was going to win this. It's just crazy talk. But it served its purpose, which is that Tanya Chutkan had to vacate the court date in March that was originally set, and now this pushes the trial back a little bit. So every day that Trump can delay judgment on him, that's a good day for Trump. And so, that ended yesterday, but he's not going to trial, for a while longer. I think tomorrow, the hearing that we're going to, and getting a sense of what the questions are from the Supreme Court as to whether Trump can even be on the ballot, could negate really a lot of need for us to even think about these things. I mean, his trials will go on, but it does seem, and again, I don't like to make predictions, especially about the Supreme Court, but it really does seem to me that there's a really good case for disqualifying Trump from the ballot in every state of the union.
I think that they should, and I wish that they would do that. And I don't understand why everybody is so afraid to make that decision that clearly needs to be made.
Well, I think you've got to remember that the law is not written very specifically. The 14th Amendment, third clause, is not specific. What is insurrection? We have definitions in the Constitution of what treason is, but we do not really have a firm definition of what an insurrection is, what constitutes an insurrection. It also does not lay out whether or not you have to be convicted. In most cases, due process of law has to have gone through, and you have to have been convicted of an act for you to suffer the penalties for having committed that act. In this case, yes, the court in the lower court in Colorado did find that he had engaged in insurrection. He did have an opportunity to fight that decision. He had not. That was a fully open court. Arguments could have been made. He chose not to really engage in that very much. So the decision was made that an insurrection happened, but it was not convicted. It's not like he went to jail like some of the Proud Boys or something like that, or those type of people. So that's where the question comes. I think the Supreme Court tomorrow will try to find an off-ramp somehow in some wording that they define. I think it's probably going to be a 5-4 vote, but I think they're going to allow him to stay on the ballot. That means that this decision yesterday about his immunity becomes even more important, because now if you're going to avoid having a second Trump administration, which I think all of us are terrified of, that's the way to get it. That's the way to end this. Now, will he still get a whole bunch of votes? Absolutely, because there's just people out there that are going to vote for him no matter what. But I think that his chances of getting elected while he sits in jail or while he is a convicted felon, I think that the moderates and even some of the less far right conservatives are going to look at it and say, no, I can't do it. I mean, you just can't do it. So in a way, it all plays together. At the same time, the Supreme Court, just to say, could look at the decision from the D.C. Circuit, 10th Circuit, and could say that even the D.C. Circuit said that he did something wrong. They can interpret that out of that 57-page decision of theirs. So there's a lot of ways this would go. The Supreme Court, yes, very difficult to figure out how they're going to rule, what they're going to hear, and how quickly they are going to rule. But they do have they act in their own time frame. I mean, that's something. They showed something on the TV today. When you go to the Supreme Court building, the pillars are being held up by tortoises, by effigies of tortoises, and that is to show the slow movement of the law. So I never noticed. I've been to the Supreme Court building a few times. I never noticed that those pillars have tortoises underneath them, and that tortoises are all over the building to show the slow movement of the wheels of justice. So that's it. The only other interesting that happened yesterday was that Nikki Haley in Nevada lost to anybody else but.
Right, all of the above. Or none of the above. Yeah. None of the above. Yeah, that was wild.
Although all of the above, anybody else but has never won an election, thankfully. So that is kind of an embarrassing. That is a little bit embarrassing of a turn of events for the former governor of South Carolina. So that's all the time we have for today's episode. The Nova Society is a production of the Phoenix Research Institute. We'd like to thank our sponsor for this episode, the Journal of Interdisciplinary Conflict Science. The JCIS is an open journal for upcoming scholars. The JCIS is currently accepting article submissions on an ongoing basis. The JCIS is a publication of Nova Works, a scholarly depository at Nova Southeastern University. A link to the journal is in our description. We'd also like to thank our podcast partners, Buzzsprout, who hosts the Nova Society, Audacity, who is our editing partner, and Podkite, who does all of our analytics. We'd also like to thank iHeartRadio, where people get their music and podcasts, Apple iTunes, the largest source for music and podcasts on the internet, Spotify, the most popular source for the Nova Society. The Nova Society is available on all these and other quality platforms mentioned in our description. We'd also like to thank our listeners. Without you, the Nova Society would not be possible. If you have a comment, a question, or would like to be a guest on the Nova Society, we can be reached at nova.society.podcast@gmail.com. Always remember, the power of society is knowledge. So for Dr. Scott Gershwer, Dr. Brooklyn Ann Weldon, Dr. Priscilla Hobbs, and all of us here at the Nova Society, I'm Dr. Mark Bound. Be well, and we hope to see you again next time.